Parenting time is decided in one of two ways in your Texas divorce or custody case: by court order or by agreement. Now, agreement's easier, so let's start there. By agreement, you and your co-parent can put together pretty much whatever parenting time and possession schedule that you want. Sometimes you might elect to do something that looks a little bit more equal, like 50-50, week on, week off, or 2-2-3, where the kids rotate. Now, you can agree to that if you want without a court intervening or telling you how it has to go. But you're not together anymore with this person for some reason. Y'all probably don't get along and aren't able to make decisions that well together, even if it's about the kids. So you may find yourself in the other camp where a court's going to tell you how this goes. And fortunately or unfortunately, depending on what side of things you're on, the Texas Family Code lays out a default possession schedule for the parents that the legislature has said is in the best interest of the children. And that schedule is one that the non-primary parent, the possessory parent, not the managing conservator, the possessory conservator, that where they would have the children the first, third, and fifth weekends of the month, a month in the summer, and alternating holidays. And then during the school year for those weekends, the possession would begin when school lets out on Thursday and ends when school gets back in session on Monday. So that's the default schedule that will come up, and the legislature makes changes every few years to how that one plays out. So if you're going to court in a Texas custody case or Texas divorce case, and you two cannot agree on some alternative schedule, the most likely outcome, depending on the judge and depending on the county, is some version of an expanded standard possession schedule where one parent has the first, third, fifth, and the other parent has the balance of the time. People sometimes ask, what's the difference in visitation and parenting time in a Texas divorce or custody case? And it's really just a matter of usage of words. I personally don't love the words visitation. It sort of makes me think of a funeral or like you're going on a trip. I prefer parenting time. It's about the time that the parent gets to spend with the children. So really, they're usually using the words to mean the same thing. It's just their own preference or habit of which word they choose to use, visitation or parenting time. They'll also say possession schedule, and that usually is talking about the same thing. When people ask about a parenting plan, I often think they've seen this in a movie or talk with a child therapist. It's a more modern term used to describe things that historically or in modern Texas family law would be called possession schedules, parenting time, or visitation. A parenting plan, I think, is a broader term where parties might agree to do more than just talk about when the child will be where. They may come up with some other agreements in terms of like how college might be played, how they might make certain decisions. But that's a pretty freshly modern term, the parenting plan. I don't hear that just a ton in Texas divorce cases. Maybe in the collaborative divorce space, they might talk about it in terms of parenting plan, but courts are more likely to use things like possession and access schedule, visitation, or parenting time. Parenting time can be modified after divorce through a custody modification. But here's the thing, proceed with caution. What I always tell people is if you want a surefire way to break your heart and empty your pocketbook, file a custody modification. Because here's the thing, Texas courts favor stability for the child. We get that. We understand that. We don't want things changing all the time. And the courts don't want parents keeping on coming back into court time and time again and putting their kids in the middle of a whole entire custody battle. So you need to proceed with caution from filing a custody modification. You can change it, but it's absolutely not a given. And you have to make sure that you're willing to go the distance and spend the money and go through the conflict to get there. And look, some things are worth fighting for. If your child is in danger, or you can't get them the medical care that they need, or they're going into unsafe places, like that may be a situation where a custody modification is warranted. Things like your X factor is 10 minutes late every time they pick up the kid. Probably not going to be something that's worth going after a custody modification. So this is something where you're absolutely going to want to consult with a Texas lawyer to see whether a custody modification is right for you in changing parenting time and parenting plans after a Texas divorce. If a parent refuses to comply with the custody order, which is an order of the court, a couple of things may happen. Number one, there's legality, and number two, there's reality. First, as far as the law is concerned, if you don't comply with court orders, a lot of bad stuff can happen to you. You could be thrown into jail. You could have various sanctions levied against you. You could have to pay a lot of attorney's fees. All of this in the context of what's called a motion for enforcement. So it would happen where, let's say, one parent was ordered to return the children after summer break at a date certain, and they don't. And the parent who's supposed to receive the children files an enforcement to say, hey, judge, they were supposed to give the kids back and they didn't. Depending on the circumstances, a judge may really come at you and award fees and even additional sanctions and additional punishments to you in accordance with the law. Now, not everything gets to that level. Remember, legality, and then we have reality. And in reality, a lot of times what will happen if someone violates the provisions of a custody order? Nothing. They're 10 minutes late every time to pick up. They're supposed to be there at 6 p.m. and it's always 6:10. Probably nothing's going to happen to that person. I always tell people laws and rules are for law and rule abiding people. You're going to be on time because you do the right thing, but they may not. Now, if they're 10 minutes late, you probably still want to keep a note of that. And that may be one drop in the bucket where you're trying to someday build a custody modification. If you're thinking, hey, this is not fair, the co-parent that I'm stuck with keeps violating the court order, you really want to talk to a Texas lawyer to consider whether the violation is enough to warrant trying to go the legal route and get a judge to do something about it. And usually it means it has to touch and concern something important with your children, like if they're refusing to give the child their medication and they're not having the medical care they need, then it may be worth it. Some things are worth fighting for.